Welcome to the Old Capital Real Estate Investing Podcast with Michael Becker and Paul Peebles. During this program, you will hear interviews with real-life successful investors who will share their stories and provide useful advice on how to acquire, finance, and operate apartment complexes. Now, here they are, Mike Becker and Paul Peebles.
Welcome to the Old Capital Real Estate Investing Podcast. I'm your host, Paul Peebles, National Underwriter for Old Capital. And joining me today is James Eng, also with Old Capital. Hey, James.
Hi, Paul. How you doing?
I'm doing good. So we're going to talk a bit about title insurance. We're going to talk a little bit about survey. And we're going to talk about things that some people think are complicated, and we're going to try to make them as uncomplicated as possible when it comes to title work and in closing of a transaction. So the thing doesn't happen until the money from us comes together and the person's earnest money comes together and the property is available and it comes together. So the person who is kind of the air traffic controller is the closing person, the title attorney, the closer for the title company. And today in the podcast, we have Kelli Lovelace. Kelli Lovelace. And Kelli is not only a title company closer, but she's also an attorney too. So, Kelli, how are you?
I'm great, Paul. Thanks for having me.
Thanks for coming into the podcast. Kelli and I have been friends for a long time. Not only are we friends, and we've done a lot of business together, but we have the same birth date. Did you know that, James?
I did not.
And not only the same birth date, the same birth year.
Wow.
And we're not going to tell anybody
not going there.
what year that is. But her and I have been friends for a long period of time. I think she's probably the most highly qualified commercial closer / attorneys in the DFW area. So we're going to talk a little bit about closing a transaction, some of the paperwork that has to be gone through, approved, and reviewed. So let's kind of kick it off with you, Kelli. What is title work? I mean, what is a closing? What exactly do you do?
Well, typically when we get a transaction started with title, we will either get a real estate sales contract or we will get a title request on a refinance transaction from the actual lender or the broker. So with respect to a sale, the transaction that I begin working on is upon receipt of the contract. So some states, Texas is one of the states that has both title and escrow services provided in the same office. Other states, such as California, will have your title insurance separate and apart from your escrow agent. So you kind of need to be aware of who the players are.
Okay.
So with Texas, the title company typically acts as both title and escrow. Escrow meaning simply the holder of the funds. So we accumulate, air traffic controller was a good term, we accumulate all of the invoices, we hold the money, we make sure that the distributions are made at the time of closing and funding.
And so once you say you receive the purchase and sale contract, what is the first thing that is sort of your first deliverable after receiving that?
Okay, so the first thing that I do is that I will place an order for title insurance with my underwriter. Okay. The underwriter is then responsible for examining the abstract of title. Abstract of title is basically the history of the property, and it is basically every document that has ever been filed of record with respect to that particular parcel of land.
So that's something that could go back 100 years?
Exactly.
In the state of Texas, it goes back to the period of time that the Spanish?
We go back to sovereignty, so upon the state of Texas. So
wow.
So you put in the order to the underwriter, and then how long does that typically take from once someone orders that?
Well, that's a good question. And you can really help yourself out a lot in the negotiation part of this by having some of the documentation provided by your seller. So if your seller has its current owner's title policy, ask for that as one of the documents that you want to see when you're looking at the critical documents from your seller. And if you can provide that to the title company, that kind of gives them a kickstart. So typical time frame on a commercial transaction would be 10 business days. So if you're drafting into your contract terms, you're going to want to give yourself, I would give myself 15 days if you're using calendar days in your contract for the production of title.
So is that the title pro forma or is that separate?
So after the abstract work is prepared, we prepare a commitment for title insurance. Okay. So title insurance then is actually insuring the different parties and their different estates and title to a transaction. So the lender's perspective would be different than an owner's perspective.
Okay, and then how would that be reflected? Is this two separate policies, or is that one policy for everyone?
It's two separate policies. So the owner's policy would be separate and apart from the lender's policy. The lender's policy in the state of Texas, we have the ability to combine rates with respect to a simultaneous issue of an owner's policy and a loan policy. So now we're talking dollars and cents here.
Right.
So the title insurance cost, as it is borne by the parties, would be a base policy amount based on the sales price of the real estate. And then the loan policy, so long as it does not exceed the sales price, if issued simultaneously with the owner's policy, would be $100. The rates in the state of Texas are promulgated. So that means the legislature has actually come out and set the rates for those particular dollar amounts of insurance. Some states you can actually negotiate based on the $1,000 sales price for your title insurance cost. And then other states are promulgated like Texas.
So what does that mean? I mean, we have an owner's policy and a lender's policy. I mean, kind of define what an owner's policy is and what that goes on to protect you, and what is a lender policy? What does that go on to protect me?
So the lender's policy would be more to ensure the lender as to a priority scheme, where their loan's going to fall in a priority scheme with respect to.
So this is some of that attorney talk.
So bring it down to more Title 101 for us. Yep.
So most states have a race to the courthouse rule, where whoever gets there first is first in time to make a claim. So if you're the lender, you always want to be first because you want your loan protected. So a priority would mean that the lender would be first in time with respect to any liens outstanding on the property. So one of the things that the lender would be looking for is to make sure that there are no outstanding debts, liens, any kind of abstracts of judgment, any kind of lawsuits that would prevent that lender from coming into play as a first lien holder.
Okay. So they want to be the first one at the table and no one in front of them. So that's why that policy is protecting them on that regard. And then the owner side, how are they?
The owner, you've got a lot of money invested into this real estate that you are going to purchase. So one of the things that you would want to make sure is that once you actually sign on the dotted line, that you are going to be the owner and that there's not going to be somebody that's going to come in and usurp or surpass your rights to ownership of that. So that's what title insurance is designed to cover, is that you have the right to that piece of property. And if somebody comes in to make a claim with respect to ownership, that is not something that would eliminate you from the ownership of the property.
Okay. Is that different than clouding the title, or is that just a separate terminology?
Clouding the title is more in line with it could be an ownership issue or it could be a lien issue. So clouding the title would just mean that you would create a circumstance that would need to be addressed prior to actually closing
the loan. So the lender has first position and the owner knows that it's clear.
The owner knows that he's the owner of the property, right?
Okay.
Once he hands over his money, he wants to make sure that deed that he is buying, that land that he's buying, is actually going to be in his name.
Okay.
Let's break down what a title commitment looks like. I mean, there's different schedules within a title commitment. There's a Schedule A, B, C, and a D schedule. And so when somebody has a commitment that comes back and they want to review it, the first thing they do is they look at this piece of paper that has, 4 different schedules on it. And what are they looking at? What is a Schedule A?
Okay, so the title commitment should also be accompanied by the title evidence, which would be the documents that you're going to want to review in conjunction with the title commitment. So the title commitment, Schedule A, basically is who's being insured and what's being insured. So who would be insured on Schedule A would include not only the owner but also the lender on that transaction.
And the amount too sometimes.
And then the loan amount as well as the sales price.
Okay. And then what goes on to the Schedule B?
Well, in addition to that, on Schedule A, you're also going to be looking at what is to be insured. So you're going to be looking at the legal description of the land. So when you're looking at your title insurance commitment, it's kind of an outline for the transaction, if you will. So you want to have certain things to look at to compare to the commitment. So you want your survey. If the seller's going to provide you with an existing survey, go ahead and have that. I'm a huge fan of getting your own survey, especially on a purchase transaction, because you're going to want to make sure that you have the most current, up-to-date information. One of the instances that I can recall of late is that some of the FEMA maps in the state of Texas have recently changed. And if you're relying on an old survey, you may get hung up in your underwriting process with the lender when they come out to do a flood certification where the FEMA maps have changed. The flood certificate is no longer valid on your existing survey. So if you would have had the new survey, you could have compared where the FEMA maps lie and whether your property is now located in a flood zone. So that could be a huge cost factor if now you're required to purchase flood insurance on a piece of property that you're looking at. So I always suggest that you have existing survey for a preliminary review of the title commitment so that you can kind of see what land you're looking at. Make sure that the legal description matches with the vesting deed. So a vesting deed would be a deed that is currently held by the current owner of the property that reflects that they are the owner of the property and what land they own.
Okay. So sometimes we run across where they say title will not insure based on the current survey, and sometimes they will. How does somebody on the title side know, or how would we know? I guess if we're looking at an acquisition and the seller provides us a survey, how do we know if that will be accepted on the title side?
That's a good question. If the survey that's been provided by the seller is incomplete, so maybe they just gave you a copy of something and didn't actually give you the entire survey. If there have been any improvements to the property since the time that they bought the property, if they've added outlying buildings, if they have done improvements to the property such as adding pools and hardscape that would affect, such as patio areas,
the structures onto the property that weren't reflected on the original. Okay.
Any kind of easements that might have been created since the time of the last survey.
If it doesn't have a stamp from the engineer, or if the ALTA rules have changed from what it was back when the survey was in effect, say 10 years ago or 15 years ago. So sometimes mostly time can invalidate a survey.
Right. And then the other thing that you want to look at when you're looking at your survey too is to make sure that you have access to the property. So you're going to want to make sure that you can, when you're looking at the picture, which a survey is basically a bird's eye view of what your property looks like, make sure that you can actually see curb cuts from a thoroughfare or an easement tract. So if you're getting access to your property through an easement, you're going to want to have not only your property surveyed, but the easement effect surveyed as well.
Okay. Anything else on Schedule A?
The other thing that I would have to compare on Schedule A would be your tax certificate to make sure that the tax office is matching the property description that you're showing on your commitment.
Okay.
So that's kind of a lot to cover on Schedule A.
And so you're putting this together on the title commitment, and then when you send it to the owner to review, anything in particular that they should be looking at, or is it more just a verification of everything that they thought they were buying?
I think it's more of a verification of what they're trying to buy, making sure that they have in their mind's eye what their contract means.
Okay.
So then moving on to Schedule B of a title commitment, that's going to be things that have occurred in the history of the property that might affect that particular piece of real estate. So those things would be restrictive covenants. A common example of a restrictive covenant would be to have a size of a building. Sure. So you can't have a building smaller than 800 square feet on this particular piece of property.
Right.
If there are any kind of easements with respect to the properties, some of the easements you're going to look at and you're going to go, yay me, those are great easements to have because you're going to want to have your property serviced by utility companies.
Right.
Water, sewage,
those
electric
are all
companies. Standard things that you're going to want to look for. And probably if you're looking at the plat, they'll be laid out on the plat. But you'll also want to look to see if you actually have a filed easement to read through that, just so that you understand what rights those particular people have with respect to your piece of property.
Okay. So we've come across an issue where, we're looking at the Schedule B and there might be something along the lines of a HUD restriction where there's a certain number of units that have to go for some amount of income on a property. But in the Schedule B, it just sort of listed the document and that was it. So it was hard. We sort of caught that at the very end. Is there any way to be more proactive, or who should the owner know that, or should the attorney or the title company? How should we go about things like that, or how do we figure that out?
I think the faster that you can get your title work and actually look to the underlying title evidence. So you're looking at your commitment kind of as the outline.
Right.
Then you want to read carefully all of the backup that you have. So if you have Schedule B, if you have 10 things listed on Schedule B, you want to make sure that you have the actual filed copies of all of those items so that you can review each one of those. Just because something is on Schedule B doesn't mean that it's there permanently.
Okay.
A lot of times, one of my favorite examples is laundry leases,
Right.
if you're into multifamily transactions whatsoever. Laundry leases, a lot of times companies will come in and out of business.
Right.
And CoinMock has bought up a lot of companies. But the one thing that they will do is not go back and release that old lease, old laundry lease. So you always will have an old laundry lease and a new laundry lease. So you have to make sure that you can figure out why we have two laundry leases. Are there actually two laundry companies?
So
the odds of that happening are no.
So why do they want their lease recorded?
A recording of any kind of document at the county clerk's level with respect to real property only puts third parties on notice of what the actual transaction is. Okay. So you're actually letting the whole world know that you have a laundry lease out there.
Okay.
Things filed at the county clerk's office are deemed to be public record.
Right. So
there's no secrecy there.
Okay.
Let's go back for that just one more time, James, because a title commitment is, just like what Kelly was saying, is just kind of an outline. And it's an outline of things that have been recorded in the past. And these are actual documents that are recorded in the past. And Kelly and many other title companies can pull up that recorded document. So if you see something on like a Schedule B that says that there's a CoinMac laundry lease, well, there is a CoinMac laundry lease that came up when they were reviewing title to the property, that it was never released. So you can actually ask the closer, what does this mean? And she'll go into her computer and pull it up, or pull the microfiche of that document up and show you that this is still on the property and a release was never recorded. Whether it's that or something else, but all those items that get pulled up on the commitment are real things that are still showing on title of the property that have to be released. So your question concerning that HUD document on there, I mean, that was a document that the title company, not Kelly, should have found out right from the beginning that was an underlier onto the transaction, and that should have been brought to the buyer's attention. The seller knew about it, I'm sure, but never brought it to the buyer's attention. And then the buyer should have told us or told you immediately that was on there. And this was one of those things probably at the time was just missed, and it was never brought to anybody's attention.
Right. So anything else on Schedule B while we're there, or you want to?
Well, I think you ought to realize, too, that when the title company issues their initial commitment, that's kind of the biggest and most in-depth look at your property. That doesn't necessarily mean that all those things are still alive and still valid. And you can certainly look through the commitment, match it up with your underlying title evidence documents and say, hey, this looks to be like it has been released, or it should have been released based on its terms. Can we remove this particular item? Okay. So make sure that you have a good rapport with your title company and just go back to them and say, these are some of the things that we're seeing that we don't want to have on our final title policy when you issue that.
Right.
Yeah, because the lender's going to require, like that laundry lease that was done in 1973 that still had never been released. They're going to want to have that off of there. And they're going to tell the title company, when we close, we don't want to see that a 1973 lien against the property.
Correct.
Okay. Schedule C?
Schedule C is kind of the money transaction part of this. So when you're looking at Schedule C, you're going to be looking at anything that has been recorded, which would be a monetary item, a first lien from a lender, a mortgage lien from a lender, any kind of tax lawsuits. So whether that would be from an ad valorem property taxes based on the local, county, school district, city, or state. You might see an IRS lien associated with that. You're going to look for things like mechanics liens. You're going to look for things like abstracts of judgment that might have been filed. And one of the things I'm going to tell you too is that when you're looking at those things, we pull name searches at the title company, and the name searches may be identical to somebody else's name or close enough that we're suspect. So we're going to go ahead and include that and make you answer. There's a Paul Peoples here that filed bankruptcy in 2010.
Right.
Is that you? So then Paul can identify himself and say, no, that is definitely not me.
That's definitely not me.
Definitely not Paul.
But there's not that many Paul Peoples out there, but there could be, William Smiths or Bill Joneses, and there could be, child support lien that's out there looking to get placed on somebody, and that's what's going to show up on that Schedule C, that you want to disavow that person or that lien is you.
So on the Schedule C, are you searching by the entity that owns that property? So if it's an LLC, though, there could be some common names for LLCs, but versus it being a residential property where there could be a lot of names on the ownership. So on commercial, does that come into play a lot or no?
On commercial, it does to a degree.
Okay.
Because the lender is going to come back to me at the title company and say, hey, we really like that search that you did on the LLC, but we've got Joe Smith here who's going to be a guarantor on the underlying lien, and we are going to want you to do a name search on him too, especially when Joe Smith is a single entity, single shareholder LLC. So he's gone out and incorporated himself. He's the only person involved in that LLC.
Right.
And he's now going to buy this particular piece of property in the LLC, but he's actually going to be the one putting up the money to buy it and making the payments and managing the property. So the lender's going to come back to us and say, hey, do another search. We're going to expand the search that we're going to do here and look at this guy's name as well.
Okay.
So that would be both on the buy side as well as the sale side. So you're talking buyers and sellers both.
Now, on the seller side, you have to verify that the person that is selling this property has the right to sell the property. Not only do they own the land or their LLC owns the land, but they're the right person to be able to sign on behalf of the partnership to sell the property too. So talk with me a little bit about what it takes to find out that you get the rightful seller of the property.
Okay, so we're going to do a request for information to both the buyer and the seller, because on the seller side, we want to know that you're looking to who actually is the right person to execute the corporate documents for this particular entity. So we're going to look for any kind of articles of organization, original partnership agreements, any amendments to those documents. We're also going to be looking for articles, the business operation agreement, and then the final thing would be corporate authority in the form of shareholders' consent and an authorization for a particular agent or officer of the company to execute the documents on behalf of that entity. So you got kind of multi-steps there. You want to know that the company has been organized, that it is still is in existence, that there are not certain things that the company's put together in its own operating agreement or operating plan that would preclude it from selling a piece of property, and then that you have 100% of the shareholders or partners in agreement for the sale of that particular piece of property.
Okay. Anything else? I guess what comes after the schedules? Is there anything else after that in terms of endorsements or exceptions after that?
Well, to finish up with the schedules, you've got Schedule D, and basically that's who you're doing business with respect to the title company.
Okay.
Who the officers and directors of that particular title company are. And it also gives you an idea of, there's a little mini schedule on Schedule D of what the cost of the title insurance is. So if you don't see that on your Schedule D, call the title company and make sure that they include that on your Schedule D.
So a lot of times we're asked, what are my closing costs going to be? And so how, if someone's trying to figure out how much title insurance is going to be, is there an easy way to estimate that?
You can look to Schedule D, which would be only the title insurance piece of it. Okay. So if there are escrow fees, recording costs for other services such as tax certificates and things like that, you're going to want to go to your escrow officer and have them do a quote for you.
Okay.
In the state of Texas, every title company, when it comes to the premium on the title policy itself, it's all the same. So if you get a title policy in Austin, Texas versus Houston versus Sherman, Texas, it's all going to be the same. Not the only thing that changes is that if you have $100,000 coverage versus $1 million, there's going to be a cost difference, but it's the same wherever you go. So there's no difference in title policy costs. It may be different in different states, but in the state of Texas, that's how it runs here.
Sometimes I've heard if someone brings, let's say you just bought your home or you just bought the multifamily and now you're refinancing it. So you just did a closing a year ago or 2 years ago. Does that help in any of the savings on the title insurance, or is that?
The only time that we can offer you a credit in the state of Texas on a loan policy would be if you had done construction. It's not technically a credit, but the way that the title rules work, you would save some money with respect to if you'd had a loan policy on a construction, and you're now getting out of that construction phase going into permanent, or if you merely bought the piece of property with a loan and now you're going to refinance, you'd be entitled to a refinance credit.
Okay, so on the refinance credit. Okay.
Right.
Gotcha.
Yeah.
Okay.
And that's called an R8 credit in the state of Texas.
Any other things we should keep in mind on sort of unique things maybe here in Texas on title insurance that differ, or is it pretty standard across the U.S.? How anything here in Texas specifically?
Well, you're also going to be looking at certain endorsements, which you had mentioned. Okay. So you have your basic policy of title insurance. Now, the commitment is basically what we are willing to insure. The policy would be the final product. Okay. So the policy would also include any endorsements to coverage. And in Texas, it's a laundry list of things that you can purchase as additional coverage. And one of the things that's often purchased is, from a lender's perspective, is a tax endorsement to make sure that there are no taxes unpaid at the time of closing. There's another endorsement that's typically called a comprehensive endorsement, which is T19, which would just ensure the lender for restrictions, covenants, and encroachments, so that the lender's not going to be held up with any kind of claim with respect to a restrictive covenant that was violated. Another endorsement that's common on multifamily transactions is an environmental endorsement. It's only allowed on residential property. It's not allowed on any type of commercial property other than residential. And that one you need actually to get specific underwriter approval if it's more than a 1 to 4 family residence.
Okay. So you guys, the title insurance is providing these endorsements more so for the lender. So the lender will come back and say, this is a great title commitment, but we need T19 or T33, any of these different endorsements.
Correct.
To satisfy their requirements. And are you seeing different requirements maybe from local banks versus agency lenders? Are they pretty much the same, or is everyone looking for the same type of endorsements?
Everybody pretty much looks for the exact same type of endorsements in the state of Texas. So you want your taxes covered. You want to have access to the property covered to make sure that you have a legal way of accessing the property, which is important if the lender's going to foreclose on the property. Sure. They want to know they can get in and out of the property. Right. The comprehensive endorsement that we had talked about. But some of these endorsements are also available to the owners as well.
So why would an owner need an additional endorsement if the lender already has it? 2
different policies.
Okay.
So the lender's policy covers nothing on behalf of the owner.
Okay.
So the owner policy stands by itself. The loan policy stands by itself.
Okay.
So it depends on who you're talking about insuring.
Okay.
So you have looked at the title commitment. You've reviewed that. Everything else makes sense. A, B, C, D schedules. You're ready to close. Tell me a little bit about the closing piece. Can you have a power of attorney close with you on an LLC? When should the money get to the title company? When should you sign your loan documents? Tell me a little bit about the timing issues.
I think on the timing issues, if you have a contractual date for closing, you ought to at least try to have all of the loan papers executed at least 3 business days prior to your actual closing. Most title companies these days are requiring on commercial transactions that you wire funds to the title company. I would like to have all the funds at title at least 24 hours prior to closing, if not 48 hours prior to closing, so that we know that we have all the money available to actually finalize the transaction. I try to make sure that we do a final checks and balances to make sure that anything that the lender is showing that they needed to have as a requirement met, that we have that met way in advance of closing.
How about the payoff from the seller? When does that have to be ordered?
The seller, as long as they are looking at a national structure, such as a Fannie Mae or Freddie Mac transaction, you're going to be looking at a 30-day notice to them. So you're going to want to have that ordered way in advance. If you're dealing with a local bank, you may be able to get by with something more like a 2-week notice. But there's no sense in not just going ahead and letting your lender know 30 days out that you're going to be closing and paying off their loan.
And you have to wire the funds in. You just can't bring a personal check. I mean, it may sound stupid, but some people just think they can write a check at the closing table to close on the loan.
The media is fraught right now with all kinds of reports of fraudulent cashier's checks. So title companies are really laying down the law on making sure that funds are wired and that they're wired in advance of closing, not same day as, so that we can verify funds prior to closing.
Now, you close on the transaction and you get all loan documents back and the deal becomes mine or becomes the new owner. Are you guys out of the transaction after that? Is there anything that happens after the loan closes on your part?
After the loan closes, the title company is provided with a set of written closing instructions. So we are obligated at that point in time, not only as the title officer, but as the escrow officer, to disperse funds in accordance with those closing instructions, as well as record the documents. So the documents that I would be referring to would be any kind of deed conveying title from a seller to a buyer, any kind of mortgage or lien established by a lender. You may also look at an assignment of rents and leases if you're doing multifamily or any type of commercial strip centers, things like that. We're going to have tenants associated with the transaction. And then any kind of subordination, non-disturbance, and attornment agreements. And those would be simply, if you had the CoinMock lease, you'd want to make sure that CoinMock knew that the ownership had transferred and that there was going to be a new lender in play as well. So they subordinate their interest to that new lender.
Is there anything, recent transactions, we've talked a lot about the schedules and looking at them, but maybe take us through maybe a transaction or two recently that you've closed, that there was something unique about that transaction that you would want new multifamily investors to know about, just so that they could catch things up front versus, a couple days before closing.
Right. So one of the things that I always find interesting is that lenders try to be really good about documenting their transactions. And when we pay off a lender through a wire, those funds transfer immediately. So the lender has their money for the payoff, and they're happy about that. What I want to make sure that we convey right now is that you need to follow up with your lender if you're the seller, that lien has not only been paid off but released.
Released, sure.
So the lender needs to provide me at the title company or the seller with a copy of the executed and filed release of lien.
Okay.
Most lenders have taken that on as their responsibility to go ahead and record the release of lien upon the receipt of funds. So that's one of the things that I would like to just impress upon you, is to make sure that you follow up and actually do that final step of getting that release lien. After closing, the seller should have received from their lender their final note marked paid in full. Right. This is the seller again.
Right.
So paid in full, and the deed of trust also stamped accordingly. And then the release of lien. Recently, we had a transaction where a national lender had just out of the blue pulled a legal description, put it on their deed of trust, and filed it. So not only are they running the risk that they don't have their lien covered on the right property, but now they have clouded my title to the property that we're working on. So trying to get that item removed from my client's title,
sure.
It's kind of a nightmare and a big hassle because the lender is trying to make sure that they keep their interest on a go-forward basis with that lien because they haven't been paid in full from the actual mortgage.
Right.
So they've got kind of a dual role here to play. They've got to fix this one thing that they messed up while preserving their interest in the right property. So that was kind of interesting working with them.
Okay. So it sounds like just getting the title commitment early on in the process, working through any issues that come up with your title officer is the big thing.
Yeah, and I think just basically communicating and staying in touch with the title person so that they know what's expected of them. One of the best things that you can do in advance of closing is to request from your title company, hey, what's my final title policy going to look like? Okay. This commitment's all really great and swell and everything, but some of the stuff doesn't seem to apply to my transaction. So can we get down to the nitty gritty and can you actually produce something that I can see as a final product in advance of me actually paying all this money? That's called a pro forma policy. Right. Those are only issued and only available on commercial transactions.
I mean, we ran into this issue once or twice with smaller title companies and we asked for a pro forma and they did not give it. So have you run into that issue?
No.
With any?
No.
Okay.
I would encourage you to do that. And quite frankly, it makes my job so much easier because I have all of my I's dotted and T's crossed before I actually do the final escrow part of it, before we actually go to the closing. So you know what your policy is going to look like. All I basically have to do at that point in time is plug in the recording information, which is the date and time stamp of the recording of the documents.
Right.
And then my policy is complete. So it comes back to you as the pro forma that you've issued. You've looked at it. You've already approved it. This looks good. This looks like the kind of insurance policy that I'm going to want. And all we have to do then is get the recording back and plug those numbers in.
So you buy the property, you apply for the loan, you close on the transaction, you operate the property for a number of years. Someone says, I'm going to give you a ridiculous price for that property and I want you to sell it. And you say yes. And then now you have to go out and find another property for a replacement on a 1031. Do you guys handle the 1031? I mean, sometimes that's a title company group. Does your group handle 1031s? And just give me some basic knowledge about 1031s.
Chicago Title has a division that does handle 1031 transactions, and 1031 is the IRS code that affords a safe haven for people in real estate. It does not cover any kind of homestead. So if you're looking at just any kind of real estate transaction, it's not going to work with respect to 1031. It has to be investment property, and typically it's a like-kind exchange. So if you're in multifamily, you're going to go into some type of other kind of real estate transaction. So it may not necessarily have to be multifamily, but just some type of income-producing property. You need an intermediary to cover that part of the transaction so that the funds don't actually get deposited into the seller's pocket. So the 1031 is a great mechanism for you shifting taxes to the future with respect to the sale of current property. So you sell a piece of property today, you're going to buy another piece of property because you're in the business of owning real estate. You're buying the next piece of property. It's a great idea to get a 1031 company involved at that time. The documentation from the title company standpoint isn't that great. We do have requirements under the IRS code that the buyer and the seller both agree to this particular transaction. So it's going to be a discussion that you're going to have with your buyer as well as your seller at that time. You're going to hire an intermediary, and typically they work on a flat fee basis. I mean, you can get a quote from any intermediary at that time, and then the documents will be drafted according to the instructions from the 1031 company.
But typically on something like that, you have 45 days to designate, and you have 3 choices to designate, and you have 180 days to close. If you don't close, that's option number 4, which means that you have to pay the taxes on it.
Right, but it could be just shifting the taxes to the next year. Yeah. So depending upon when you're actually closing. Could just be forcing the taxes into the next tax year. So it's not necessarily a bad thing to not do it if you don't feel like you're going to have your exchange property. It could be a strategy that you use, but I highly recommend that you talk with a tax attorney and your CPA before you go into that, just that you know all the ins and outs of that. It's not necessarily a slam dunk, is what I'm trying to say.
Sorry, I just missed that shifting portion. So let's say you sell a property in November of this year. Could you put it into, and you don't take the money, you put it into a 1031, and then next year in 2017, you can't find a property. Are you saying you recognize the income in 2017?
Correct. But again,
Okay.
I would suggest that you talk with your tax person.
Of course, we're not
get the advice from a tax person on how to actually do that.
Okay. Any funny stories when it comes to closings?
Oh, goodness. It seems like there's just so many. I mean, the bottom line to this business is that it's not about the real estate. It's about the people that are buying the real estate.
Sure.
So it's just the idiosyncrasies of the different people that you work with. So there's a million funny stories. But
Yeah. Kelli is probably the best in the business. As you can hear, she knows her stuff. She's been doing it for a long period of time. She's a graduate of Texas Tech, not only undergraduate but law school too. She's been in the business for as long as I have, however long that's been. And her and I have worked together on numerous transactions, and she definitely knows her stuff and just a very good resource. That if you're looking to get information about on closings and you want to have somebody as professional and knowledgeable as Kelli, she's the person that I would want you to talk with and visit with. Kelli, if somebody wanted to reach out to visit with you, what's the best way, whether it's an email address, to get a hold of you?
I'll give you my direct phone line and then my email address both. So my email address is K, first initial K, Lovelace, LOVELACE @HLF, like Frank, title.com. And my direct phone number is 214-546-3366.
Sounds great. Can I get that telephone number again?
214-546-3366.
James, any other questions before we say goodbye?
No, this has been great. Thank you very much for coming in and speaking with us, and we learned a lot.
Oh, great.
All right. Thanks, Kelli. Appreciate it.
Thanks, guys.
Thank you for listening to the Old Capital Real Estate Investing Podcast. Please join us at oldcapitallending.com to sign up for our weekly email updates. We'll see you here next week with another great interview.